Welcome to the Daily History Chronicle. Each day, we travel back to discover a pivotal moment that changed the world. These aren't just dates and facts. They're stories of courage, conflict, innovation, and consequence that still echo through our lives today. Are you ready to explore? Let's see what happened on this day in history.
Good morning and welcome to today's episode. I'm Richard Backus, publisher of University Teaching Edition, and each day I invite you to join me as we reflect on a significant moment from our shared past. Today is November 20th, and we're looking back 80 years to November 20th, 1945. In a courtroom in Nuremberg, Germany, 21 men sat in the dock facing charges unlike any in human history. They were Nazi leaders accused of crimes so monstrous that existing law had no adequate terms to describe them. The International Military Tribunal, what we know as the Nuremberg Trials, was about to begin. This wasn't simply a trial of individuals. It was an unprecedented attempt to hold an entire regime accountable for systematic atrocities. It would establish principles of international justice that remain foundational today. That waging aggressive war is a crime, that following orders is not a defense for atrocities, that heads of state are not above the law, and that some acts are so fundamentally wrong they constitute crimes against all humanity. But Nuremberg also raised profound questions we're still debating. Is victor's justice true justice? Can international tribunals be fair? How do you balance accountability with reconciliation? And who gets to define what constitutes a war crime when powerful nations escape scrutiny for their own actions? When Allied forces liberated Nazi concentration camps in 1945, they found horrors beyond imagination. Mountains of corpses, emaciated survivors, gas chambers and crematoria, meticulous records documenting the systematic murder of 6 million Jews and millions of others, Romani people, disabled individuals, political prisoners, Soviet POWs, and others the Nazis deemed unworthy of life. The world had known war before. It had seen brutality, massacre, and occupation. But the Nazi regime had industrialized genocide with a bureaucratic efficiency. This wasn't the fury of battle or the chaos of occupation. It was a methodical program to exterminate entire peoples, documented in official reports and carried out as state policy. The question was simple. What do you do with the architects and executors of such evil? Some argued for summary execution. Winston Churchill initially favored simply shooting the top Nazi leaders without trial. Joseph Stalin suggested executing 50,000 German officers and technical experts. The desire for vengeance was understandable. These men had caused unfathomable suffering. But the United States, particularly Supreme Court Justice Robert Jackson, who would become the chief American prosecutor, argued for something different, a trial under law. The Allies would establish an international tribunal, present evidence, allow the defendants to mount a defense, and render judgment according to legal principles. It would be justice, not vengeance. Law, not lynching. This was revolutionary. Never before had an international court tried government leaders for their official actions. Never before had aggressive warfare itself been prosecuted as a crime. The very concept of crimes against humanity was being created to address acts for which no adequate legal framework existed. 24 Nazi leaders were indicted, though only 21 stood trial. Martin Bormann was tried in absentia. Robert Ley committed suicide before trial. Gustav Krupp was deemed too ill to stand trial. The defendants who appeared represented the Nazi power structure. Hermann Göring, Hitler's designated successor and commander of the Luftwaffe. Rudolf Hess, Hitler's former deputy, Joachim von Ribbentrop, the foreign minister, Wilhelm Keitel and Alfred Jodl, military chiefs, Albert Speer, the armaments minister, Julius Streicher, the virulent anti-Semitic propagandist, Ernst Kaltenbrunner, who headed the Reich Security Main Office that coordinated the Holocaust. These weren't low-level functionaries following orders. These were men who gave the orders, who designed the policies, who knew exactly what they were doing. They faced 4 counts: conspiracy to wage aggressive war, waging aggressive war, war crimes, and crimes against humanity. The first 2 charges focused on Nazi aggression, the invasions of Poland, France, the Soviet Union, and other countries. The latter 2 addressed how the war was conducted, the murder of POWs, the abuse of civilian populations, the systematic extermination campaigns. The evidence was overwhelming. The Nazis had kept detailed records. There were films of atrocities, documents signed by the defendants ordering deportations and executions, testimony from survivors. The prosecution presented 240,000 affidavits and depositions. The Nuremberg Trials established principles that transformed international law. First, aggressive war, starting a war of conquest, was itself a crime. This was controversial. War had always been considered a political act, not a legal matter. Sovereign nations could make war as they saw fit. Nuremberg said no. Some wars are criminal in themselves, regardless of how they're conducted. Second, official position provides no immunity. The defense argued that heads of state and government officials couldn't be prosecuted for official acts. The tribunal rejected this. Being a government minister or military commander doesn't place you above the law. If you order atrocities, you're responsible, no matter your title. Third, following orders is not an absolute defense. Defendants claimed they were merely obeying superior orders, implementing decisions made by others. The tribunal ruled that obeying an illegal order doesn't excuse participation in crimes. Individuals have a responsibility to refuse criminal orders. Fourth, crimes against humanity are universal crimes that shock the conscience of all people. Some acts, genocide, systematic murder, torture, are so fundamentally wrong that they're crimes regardless of whether they violated the laws of the perpetrator's own country. These crimes are prosecutable anywhere because they offend basic human dignity itself. These principles were codified in what became known as the Nuremberg Principles, which formed the foundation for modern international criminal law. But Nuremberg had a fundamental problem that critics immediately identified. This was victor's justice. The winning side was prosecuting the losing side, with no possibility of the reverse. The Soviet Union sat in judgment at Nuremberg, despite having invaded Poland alongside Nazi Germany in 1939, despite having murdered thousands of Polish officers at Katyn, and despite having forcibly deported entire ethnic groups within the USSR. When the defense attempted to raise Soviet crimes, the court ruled them irrelevant. The United States prosecuted Germany for unrestricted submarine warfare and bombing of civilians, despite having done both extensively. American and British strategic bombing campaigns had killed hundreds of thousands of German and Japanese civilians. The atomic bombs dropped on Hiroshima and Nagasaki killed over 200,000 people, mostly civilians. Yet no Allied leader faced prosecution. This doesn't make Nazi crimes less horrific or Nazi leaders less guilty. The Holocaust was unique in its systematic nature and genocidal intent. But the selectivity was undeniable. Justice applied only to the vanquished, not the victors. Some defendants made this argument explicitly. Goering pointed out that the Allies had committed similar acts. Admiral Dönitz successfully used an American admiral's testimony that the U.S. Navy had waged unrestricted submarine warfare against Japan from the war's first day, which helped reduce his sentence. The question was legitimate. Can a trial be just if only one side faces judgment? Is it law, or is it simply power dressed in legal robes? The trials lasted 10 months. On October 1st, 1946, the tribunal announced its verdicts. 12 defendants were sentenced to death, including Goering, Ribbentrop, Keitel, and Kaltenbrunner. 3 received life imprisonment. 4 received prison terms from 10 to 20 years. 3 were acquitted, much to Stalin's fury. He had expected convictions for all. Goering cheated the hangman by taking a cyanide capsule the night before his scheduled execution. The others were hanged on October 16, 1946. Their bodies were cremated and the ashes scattered in a nearby river, so there would be no grave for Nazi sympathizers to venerate. The Nuremberg trials continued with subsequent proceedings against doctors, judges, industrialists, and military commanders. Altogether, 199 defendants were tried in Nuremberg. Allied occupation authorities held additional trials throughout Germany. The legacy was profound. Nuremberg established that individuals could be held accountable under international law. It created the legal framework for prosecuting genocide and crimes against humanity. It documented the Holocaust with meticulous detail, creating a historical record that would make denial more difficult. The Nuremberg Principles influenced the Universal Declaration of Human Rights in 1948, the Genocide Convention, and the Geneva Conventions. They provided the foundation for later tribunals, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and ultimately the International Criminal Court established in 2002. 80 years later, international justice remains deeply conflicted between the Nuremberg precedent and the problem of victor's justice. The International Criminal Court has prosecuted African leaders but has struggled to hold powerful nations accountable. The United States, Russia, and China aren't ICC members. When the ICC investigator sought to investigate alleged American war crimes in Afghanistan, the U.S. imposed sanctions on her. When the ICC issued arrest warrants for Russian leaders over Ukraine, Russia simply ignored them. We see the Nuremberg tension playing out repeatedly. Leaders face prosecution for war crimes in the Balkans and Rwanda, but equivalent crimes by powerful nations go unpunished. Saddam Hussein was tried and executed for crimes against humanity, but the invasion of Iraq that overthrew him, an aggressive war by Nuremberg standards, faced no legal consequences. The question Nuremberg raised remains unresolved. Can there be truly universal justice, or is international law inevitably selective, applied by the powerful against the weak? Yet we shouldn't let the imperfect application of justice negate its value. Yes, Nuremberg was victor's justice. Yes, it was selective. But the alternative was either summary execution or impunity. The decision to hold trials, to present evidence, to allow defense, to render judgment according to legal principles, this was progress, however imperfect. The principles established at Nuremberg, that aggressive war is criminal, that official position doesn't grant immunity, that following orders doesn't excuse atrocities, that some crimes shock the conscience of humanity. These have become foundational to how we think about war crimes and accountability. The Nuremberg trials also taught humility about what legal proceedings can and cannot achieve. Trials can establish facts, determine guilt, and impose punishment. They can create historical records. They can articulate principles. But they cannot heal all wounds, answer all questions, or restore what was destroyed. The Holocaust survivors didn't get their families back. The dead remain dead. Justice, even when achieved, is incomplete. Trials also cannot prevent future atrocities simply by existing. Despite Nuremberg, genocide occurred in Cambodia, Rwanda, Bosnia, and Darfur. International law exists, but enforcement remains political. The powerful can still act with relative impunity. Yet the Nuremberg precedent matters because it established that atrocity is not just a political or military question, it's a legal and moral one. Leaders who order mass murder know, thanks to Nuremberg, that if they lose power, they may face prosecution. That's not perfect deterrence, but it's something. The trials also demonstrated the importance of documentation and evidence. The Nazi records presented at Nuremberg made denial far more difficult. This lesson influenced how later tribunals approached documentation of atrocities. Perhaps most importantly, Nuremberg established the principle that sovereignty doesn't equal impunity. How a government treats its own citizens is not purely an internal matter if that treatment involves systematic atrocity. This principle, controversial as it remains, has become the foundation for humanitarian intervention and international criminal justice. The project began at Nuremberg on November 20th, 1945, and remains unfinished 80 years later. We have international criminal law, but not truly universal jurisdiction. We have the International Criminal Court, but not universal participation. We have prosecuted war criminals, but not consistently or without selectivity. We have established principles, but not the power to enforce them equally. The critics of Victor's justice weren't wrong. The system is imperfect, often hypocritical, and inconsistently applied. But the alternative, no accountability, no trials, no effort at justice, is worse. Imperfect justice is still preferable to impunity. The real lesson of Nuremberg may be that justice requires both principle and power. Principles without enforcement are meaningless, but power without principles is tyranny. The challenge is achieving both. Creating international institutions with genuine authority while ensuring they're governed by law, not merely the interests of the powerful. That's the unresolved tension at the heart of international justice. We want accountability for atrocities. We want legal proceedings, not summary punishment. We want universal principles. But we also want sovereignty, resist external judgment, and selectively apply standards. Reconciling these desires remains one of the significant challenges of international relations. Thank you for joining me today on the Daily History Chronicle. As philosopher George Santayana reminds us, those who cannot remember the past are condemned to repeat it. Today we explored how the Nuremberg Trials established foundational principles of international justice while also revealing its inherent limitations, the tension between accountability and victor's justice that persists in every war crimes tribunal since. Nuremberg reminds us that the pursuit of justice, however imperfect and selective, is still preferable to impunity, and that some acts are so fundamentally wrong they demand judgment, regardless of who commits them. The question isn't whether international justice is flawed, it clearly is, but whether the alternative of no justice at all is acceptable. Until tomorrow, may your day be enriched by the lessons of history.